Okay, so now let's zoom out and throw this debate open. We've heard from a member of parliament and advocate. I want to hear from Aryama Sundaram, senior advocate at the Supreme Court. With us also is Gopal Sankanarayanan, senior advocate in the Supreme Court. We've got Virag Gupta, he's an advocate in the Supreme Court. He's got concerns about this being telecast on YouTube. And we've got Deepika Kinhal. She is a senior fellow, leads judicial reforms work at the Vidhi Legal Center. So she actually researches judicial reform. Let's go across to Aryama Sundaram now on the issue of whether this is a good idea or is this a dangerous path that we've taken. Could this lead to grandstanding, showmanship of the kind that we see in Parliament, making judicial proceedings even more dysfunctional than they are at this moment? Or do you think this will throw the light of disinfection on what goes on inside those hallowed halls?
Rahul, you've asked me several questions in one, but let me just try to summarize it very easily. You see, the hallmark of a democracy is transparency and accountability. The basis of a democracy are what we call the various pillars of democracy, which is the judiciary, legislature, executive. Now, the fact of the matter is that judicial proceedings ought to be transparent, ought to be open. We go back thousands of years, at the time the Arthashastra was. You will find that it was always said that any decision given by the king should be given in. The idea was there should be a transparency to everything, there should be an openness. Now, till now, we have kept an open court system. And let me tell you something. You know, before our security problems arose, before all these recent, in the last 20 years, terrorism, security, all that, the courts used to be open to the public. I know that when I used to practice in the High Court, if there was a very interesting case, there were a lot of people who thought that was an interesting case and they'd like to hear it, and they would actually come to court. And sometimes the court would be so packed, you'd have corridors full of people to find out what was happening in court in a given case. So the fact that court proceedings are not hallowed proceedings within, closed limits when accessible only to very few people is not so. It was never so. Practically speaking, we cannot have an open court system today in that way, that because we cannot allow everybody to come in because there are a lot of worries involved.
No, but this can lead to more grandstanding. All of this was also said when Parliament live proceedings started. The monsoon session of Parliament most recently and many other sessions have been virtual washouts because the opposition won't let the government perform or won't let proceedings go on. What if the same starts happening? If you think the judge is against you...
I'm very sorry to say, Rahul.
Sir?
I'm very sorry to say, because neither the lawyers nor the courts want the court not to go on. The lawyers want the court to go on. The court wants the lawyer to go on. The lawyer is accountable to his client, who's watching all this and who also wants the case to go on. So as far as that is concerned, grandstanding is not something which is going to stop.
But you want the case to go on if you think you're winning. What if you're on a weak wicket and you think that this could go against you? Then you try and delay as much as possible the proceedings in the court, which you could try in any case, even if it's not being telecast.
Exactly. It could be done anyway. Either way, it would be done this way. It will become open to the whole public if you're doing something like that, and therefore it will be more of a control on you. It will be far more of a control. Secondly, let me tell you, you talk about grandstanding. Let me tell you that again I go back in time. There used to be crowds and crowds and crowds in court for a case, let's say the late Chief Minister MDR's election being challenged. You had no room in the High Court. You had no room within the court. There must have been about 300 people within the court, public. You think the lawyers then did not know that they were being watched? And if that was going to affect them, you think that would not have had its effect? But that does not mean anything. A lawyer is there to try to put his point across and succeed.
No, what about the concern that you say something in court, one short part of that then is excerpted by some mischief maker and then it starts viraling? It's not the full context of what you were trying to say. It's only a part, that clip is distorted.
Find the fault in them. Find the fault in them. Don't throw out the baby with the bathwater. Don't find the fault in the system. There is always a rule, there is always a system, there is always something. Somebody or the other will breach it. Somebody or the other will misuse it. But because someone could misuse it, It's not that you don't bring it in and you throw it out. In that case, every law which is made, we know the law could be misused. Does that mean we throw the law out? Not at all. And let me tell you this, the lawyer wants to succeed in this case, the client wants him to succeed in this case, and if the client feels that he's busy grandstanding and hurting his case, the client is going to be very upset with him. So let me
There are
tell
some
you,
cases
maybe
where
Parliament, the constituency expects
where
something
precedent has been that you don't show the face of the judge because the life of the judge could be in danger because it's a sensitive case. So far, proceedings for such cases aren't allowed. If going forward they are, does that then put extra pressure on the judge? A case like Ayodhya, say 370, take any big constitutional matter. Now that judge is otherwise, you know his name, but you don't really know his face, you don't see how he talks. Suddenly, his body language is being analyzed, people are psychoanalyzing every word that he says. Does that then put that much more pressure on the judge, who should be purely dispassionate, unmindful of anything outside the courtroom?
I have a very simple answer. If a person takes charge of a constitutional office, like a judge of a high court, and certainly of a judge of a Supreme Court, he is not going to be sitting and worried about either what Mr. So-and-so is going to say or whether there is going to be a danger to him if he gives a certain judgment, because that is the judgment the Constitution demands, his conscience demands. And I personally do not believe that any judge who occupies that office, that constitutional office, is going to be scared of something like
But
that.
that's in an ideal world, sir. Everyone is a human being at the end of the day. Even now, when judicial proceedings aren't live telecast, we know very often judges watch, and when we speak to them and the opportunity comes, you know, they talk about whatever happened in a particular debate. So it is 100% known that they're watching. Now, when they are being seen, that does, in effect, put extra pressure on them. Now, you can deny it, but everybody is a human being at the end of the day. He wasn't being heard earlier. Now he knows the whole nation is actually watching him.
Maybe I'm a believer, maybe I'm an optimist, but I believe a judge's shoulders are broad enough to be able to withstand it. And I believe that so far as a lawyer is concerned, he's not going to grandstand at the expense of his client. He's not going to do something which is going to hurt his case. So yes, there may be lines said, observations made, which will be misquoted. But like I said, because of that, you don't throw out the system. You don't throw out the baby with the bathwater just because some people could misuse it.
Okay, I'll leave it there with you. Arima Sundaram for joining me on the Newstrack. Thank you very much. I want to go across to Virag Gupta and understand from him his concerns. We've heard Dr. Singhvi say the jury is out. Arima Sundaram laying out a strong case for why you must give this a shot and deal with the miscreants. Don't dismiss the system. What are your big concerns?
Rahul, there are three aspects and you have discussed about the first aspect, that is misuse. Now misuse inside the court, and I think that for that judges are capable enough to handle any type of indiscipline. Second is outside the court, and that is in the social media, fake news or whatsoever may be. And the problem is judges only write their judgments and they can't defend themselves. So I think that once Supreme Court is in social media through live streaming, so they will have to make some sort of mechanism to stop fake news or to clarify, so that there is no undue interference in the administration of justice. Now the second aspect is, what is the purpose of this live streaming, and third aspect is, what should be the process. Now the purpose is, as per the Constitution, there is one Article 19 which gives the power to the general public to be informed. So what we are seeing today in the Supreme Court, that fulfills that aspect of Article 19, that people should know and they should be legally aware, because constitutional bench proceedings are giving some sort of awareness. Otherwise also, before these live streaming, there was system of digital hearing by which most of the Supreme Court clients and lawyers were able to see the proceedings, so nothing big is there. Regarding
no, but once again, when you said so casually that judges, once again, sir, Virat, when you said so casually that judges will have to find a way of being able to deal with fake news, that's a global menace. Nobody's been able to find the problem. Now, just because court proceedings are being live streamed doesn't mean judges will be able to find a way of fighting fake news.
No, what happened that some partial clipping is circulated, or their oral observations, even they are complained with the print media also that their oral comments are being misused. So for that purpose, till now, there is no social media formal platform or any segment in the Supreme Court or in the judiciary where they
or this is yet to be ordered. So I'm not going into those aspects. I am more interested to tell you about other two aspects.
Okay. Gopal Shankar Narayanan, here are some concerns. Even when the media quotes parts of what the judges say, judges very frequently complain about being misquoted or partially quoted. Now you have a situation where that clip is freely visible on social media. You can try and pull it back, but as you know with things on social media, that is a very tough ask. That clip goes viral and the judge, as Veera Gupta says, can't defend himself. What happens then?
Thanks, Rahul, for having me. I think we must look at this from the fact that the judges of the Supreme Court unanimously sat and agreed to have this broadcast. So I think they are well aware of the risks. They would have discussed all these aspects, and we have to trust them to be able to figure out how to handle it. I think somebody said earlier that the judges' shoulders are broad enough, and they are broad enough. The fact that something can be manipulated or certain clips can be put out is not a reason to avert what is ideal in the interest of the open court system and accountability and transparency. Because if that was so, then most TV channels would have to wrap up, because you could have people choosing clips of what Rahul, for example, you're saying on an evening show. I'm sure stuff like that has happened in the past, where it's misinterpreted, misused, deliberately and maliciously. But that can't really be tested. We can't look at the margins. As far as the judges making a comment or reacting to media reports, judges are human beings like the rest of us. And I think both the media as well as those at the bar and the bench have all got to realize that, look, when you're broadcasting something and it's coming from the Supreme Court, there's a sense that that would be a modicum of decorum. There would be a certain expectation that there's a high standard that you have to project. And I am trusting that both the bar and the bench will accord to that. In fact, I look forward to the fact that there will be a course correction for many lawyers and some judges who need to correct the errors of their ways when they are reporting themselves.
Deepika Kinal, since you research judicial reforms,
being a check on that.
How has the experience been globally? In the United States, audio recordings were allowed in 1955. Australia has some live and delayed broadcasting. Multiple rules are given for that. In Brazil, live audio video broadcast started in 2002. In Canada, South Africa, United Kingdom, different countries, different systems. What are the learnings internationally which India should really be looking at very carefully?
Sure. First of all, I echo my co-panelist sentiment that this is an overall positive development where the actual benefits far outweigh the imaginary concerns. And I call them imaginary because we have already tried and tested this particular aspect of live streaming of court proceedings very much here in India. 6 high courts across the country have been live streaming their proceedings for the last 1 year, and the impact has overall been positive. And as you rightly said, several other jurisdictions have been live streaming their proceedings for decades now. And no such concern has truly taken root because overall live streaming comes from the principle of open courts that all judiciary adhere to. And this open courts principle is enshrined in our statute, and it can be traced back to the Constitution, and it has been reiterated across multiple judgments of the Supreme Court. So the purpose of live streaming is it's not something that is new, something that has come into the system only now. The courts are meant to function in a transparent, open manner and ought to be accessible to public at large.
Take a sensitive case. Take, say, a case where there is a communal angle or a national security angle. So far, those are outside the purview of what will be shown live. But going forward, as this becomes more and more commonplace, that could change. Take an Ayodhya judgment, for example. When a case in the Ayodhya judgment is shown live, would there be, in any case, there are concerns to what extent would those concerns be multiplied?
So this is to do with the process, right? Live streaming and open court principle is what is applicable across board. If that is the way forward, there can be exceptions carved out for cases such as the ones that you just described. In fact, draft rules of live streaming that the E-Committee of the Supreme Court released last year has a detailed list of exceptions, say for matrimonial cases or some cases involving sensitive matters such as POCSO cases, or even on a case-to-case basis, the judges or the panel of judges, if it is say a constitution bench, can take an informed decision. And this can happen on a case-to-case basis. And even litigants themselves can apply to the court requesting the court to not live stream their particular case, and the judge can take a call. So this is a matter of process, and I don't think concerns such as this should actually go back to affecting the overall principle itself.
You're saying that these concerns are imaginary. Give it some time, you'll find that these concerns, Deepika, are very real. These are not imaginary concerns. When a judge starts complaining that one oral observation has been picked out of context and is now viraling on social media and is being used by a certain group to make a certain point, that's a very real world consequence of what is at the outset appearing to be a good idea. But we'll see what happens.
But then the video is available, right, Rahul?
No, but nobody sees the full video. Nobody sees the full video.
But at least
the
it
clip
is there.
that goes viral is just that 30, 40, 50 seconds clip. And I say this with some experience because it happens all the time. And very often isn't what someone is trying to say. But that clip then is viral in such a big way that a point has already been registered without it being the point that the speaker was actually wanting to make. And what if it's a judge who's dealing with a sensitive case at that point? But net, it brings in greater transparency. Maybe we're just being over-cautious and, playing the role of a Cassandra. It may not necessarily be required. Let's give it a shot. Let's see what happens. They're very real concerns. These are imaginary concerns, very real concerns to my mind. But maybe the net advantages of lawyers having to show up, not seeking adjournment, the client saying, "Mera lawyer kahan hai? Send me the bill," but he's not there. So all of that to some extent does get fixed. And the judge and the lawyers know people of India are watching. So you can't just do a sideshow. Everyone then can later go back to the proceedings. So there are advantages, there are disadvantages. We had a fascinating discussion. I love this. I hope that you enjoyed it too. Let's see how this experiment actually pans out. Abhishek Singh, the RMR, Sundaram Gopal, Shankar Narayan and Virag Gupta, Deepika Kinhal for lighting up the Newstrack with the power of your arguments. Thank you very much.